Hello, everybody. My name is Michael Cantrell. I'll be the host for today's webinar on mediation. Today, we're kicking off California Mediation Week, and I am joined by three wonderful panelists, Claudia, Anthony, and Shayna. And before we begin, I'd like to first turn it over to Claudia, who is our current sitting SCMA president, to welcome you all to this wonderful mediation week where we've got a new webinar every day. Claudia, take it away.
Thanks, Michael. Hi, I'm Claudia Brown Coulter. I am the president of the Southern California Mediation Association, and welcome to California Mediation Week. So if you are new to mediation, you have no idea what to do, you need a mediator, you need some help, you're not exactly sure where to go, please check out our website, scmediation.org. We have a mediator directory. You can use that and you can look up by the specific type of dispute you have. You can read about the mediators that are members of SCMA, and you can book directly with them. You can contact them directly from our website. So please check out our mediator directory. We are an organization filled with empathic, kind mediators who are happy to help you with your disputes so that you can get peace. So once again, that's scmediation.org. Check out our mediator directory. Okay, Michael, back to you. Thank you.
All right. Well, thank you all so much. Again, thank you, Claudia, for that welcoming message. As you mentioned, today's webinar and most of the webinars for this week are dedicated to people who may not understand the work that mediators do in the first place. And so today's webinar is all about breaking down what a mediation is. You can look up the dictionary definition, but in order to get an understanding of the process and what's expected of a participant, that's what this webinar is for. So to that end, I'd like to first turn it over to our panelists one at a time to introduce themselves. Claudia, we've already heard from you. Why don't you go ahead, introduce yourself as well, maybe give the audience a little background into your mediation expertise.
Great. So as I said, I'm Claudia Brown Coulter. I am the go-to mediator for navigating divorce while parenting your children with special needs. So I handle all kinds of divorce cases. I can also help you get your paperwork filed. Anthony, why don't you go next?
Boy, you really didn't do yourself justice, Claudia. There's so many other wonderful things you should have said about yourself, but hopefully everyone already knows you by now. But I'll also keep it short and sweet. Good afternoon, actually. Now, everybody. My name's Anthony Corey. I am a board member with SCMA, and I am a co-leader of the commercial employment mediation professional development group. And hopefully, if some of you have not already attended before, you'll stop by sometime on a Monday, second Monday of the month. Outside of this month, we're doing it next week, but hopefully you'll stop by sometime and introduce yourself. I became a full-time mediator 2.5-ish years ago or so. And prior to that, I had a long career as a litigator. So I come more from the litigator background. And now I'm with ARC and MCLA on their panels. I'm also AAA as an arbitrator, and looking forward to speaking on this panel today. So thanks for having us, Michael.
All right. Well, thank you, Anthony. And then finally, Shayna, do you want to introduce yourself?
Thank you so much. It's really quite an honor to be here today. Thank you for having me. I'm with the Western Justice Center. I'm the Restorative Schools Manager for El Monte City School District. And I've been doing this work for over 20 years. I got my start in restorative conferencing or family group conferencing out of Baltimore. And they're actually facilitated court diversion cases. So after moving to Los Angeles about 15 years ago, brought that skill set and found that there wasn't a lot of court diversion happening. So aligned with Loyola Marymount University, where we introduced the concept of arrest diversion and suspension and expulsion diversion. So I'll be talking a little bit today about the youth angle. Now that I'm over at the Western Justice Center, we're really aligned with school districts on a multi-year partnership. So making sure that we implement with fidelity. But talking about restorative conferencing on this platform is really exciting because it is very much aligned with mediation. So we can talk about the connections and the intersecting points together and looking forward to it.
Absolutely. And that's what this is all about, that's what this webinar is all about, is explaining how these skills and abilities can be applied across all aspects of life. It isn't something that is restricted just to a courtroom where you're dealing with lawyers. It can be applied to every stage of a person's life. So thank you all so much for joining us. Thank you, Claudia, Anthony, and Shayna, for those wonderful introductions. And let's just jump right into it. So in order to help ground our conversations about what's happening, I think it might be best to give an example of a person that maybe is going through some of the types of difficulties that your field would specialize in. So let's just take a hypothetical of Bob and say, Bob, let's start with you, Claudia. Let's say Bob has been unfortunately served with divorce papers and is thinking to himself, oh my goodness, I don't know what to do. Should I hire a lawyer? Should I, just handle this and go to court? Should I hire a mediator? Let's start first with the when. At what point should a person consider bringing in a mediator, hiring a mediator, and getting that process started? Should they wait until they've hired a lawyer, begun going to court, sat in front of a judge first? Or is there, possibilities of getting mediators involved earlier than that?
So, Bob, listen. Bob, I know you were not surprised when you got served with them papers, right? This was not a surprise to you. So hopefully you are not Bob. Ideally, Bob and his spouse sat down beforehand and knew this marriage is over. What are we going to do, right? But if Bob just got served with papers, you do not have to escalate to an attorney. It is not 0 to 60. Mediation is a pathway to resolving your disputes. And if you can't resolve all of your disputes in mediation, you still are able to go to court. You are still able to hire an attorney. There are some situations where you absolutely need an attorney to complete your divorce because it's so contentious. There's so much line. 98% of divorces don't need that. So Bob can go ahead and meet with a mediator, have a conversation. How are we going to dissolve this marriage amicably? Even if, his wife already has an attorney, or his spouse, whoever, it doesn't matter. You can still continue in mediation. So Bob's best step would be to have a conversation with his spouse and have a conversation with a mediator, because when things escalate in a divorce, because there's so many feelings involved, it just costs you more money. So don't go to a lawyer first. That's not your first stop. I see you laughing at me, Anthony.
No comment, Claudia. No comments.
Well, on that note, Anthony, let's turn to you. Let's say for you, Anthony, hypothetically, maybe there's a wage dispute that a employee has with their employer. Maybe they got overtime when they worked overtime and they weren't being paid, or maybe certain hours weren't reflected. Should this employee first and foremost hire a lawyer, file the lawsuit, begin the court process, and wait for a specific time? Or can the mediator get involved a little bit earlier?
Yeah, so my advice might be a little different than Claudia's on this. So it's good that we have different opinions.
Well,
but
it's different fields. It's different fields.
Yeah, that's right. That's right. That's exactly right. Yeah, and I do some family mediation as well. So I think that Claudia does bring up a great point. Not every case should you be rushing to go hire an attorney necessarily. But my rule of thumb, if I were speaking to the general public, which we essentially are today, is that you probably should always at least consult with an attorney in a wage and hour type case, or perhaps it's a personal injury or whatever other type of civil dispute you might have, not including family law. And first find out what are the extent of your claims. And the reason I say that is because in a wage and hour context, for example, if folks don't have a very large claim, they often can simply handle it on their own at the labor board. And the labor board is meant to handle smaller wage claims in essentially in a self-help sort of fashion. And the administrative law judges who handle those cases generally handle settlement conferences as well to try to essentially mediate those disputes between the employers and the employees. So in that kind of case, you may not need to speak to a mediator because you could go get a consultation with an attorney who says, you know what, your claim is going to max out at like $4,000, and then I'm going to take my portion of it. You're better off going to the labor board. So you can get every last penny that you're owed, for example. But that person may have a class action that their claim might be part of, let's say, that has not been filed, and they might be able to be a class rep for a class action, or maybe they have a larger claim that they weren't aware of because they were only thinking about unpaid minimum wage or unpaid overtime, and they didn't realize there are all these other claims they could file that now all of a sudden builds their claim to a max value of 50,000, not including attorney's fees. And so now you probably really should have an attorney, and then the attorney in theory would be the one to either approach the employer about trying to settle pre-litigation, in which case a mediator could absolutely be involved early on, or after the fact, meaning post-filing. As an attorney, I was involved in a number of mediations that were pre-filing, pre-litigation. And honestly, I think those are some of the best cases to mediate, because you're saving all those costs of defense for the defense side and cost of litigation for both sides. People all often only think about the cost of defense, but don't realize that on the plaintiff side, the plaintiff's attorney is expending hours, cost for depositions, cost for filing fees, all these other things, and that also gets taken out of any settlement. So it's not just the contingency that sometimes I see cases contingency 40%, 45%, 50% contingency, and then they're also taking out all their litigation costs. Like, that's crazy, right? So it really would behoove somebody to talk to their lawyer early on about, hey, I know you're in charge as the lawyer, but I really would like to pursue early mediation or early settlement discussions. And if they don't want to do it on their own, just between the attorneys, then let's perhaps look into getting a mediator. And sometimes mediators will do that at a reduced cost if it's pre-litigation, or you could go to like a reduced cost, panel like MCLA or whatever. So that's certainly always an option, but I definitely don't recommend somebody who just out of the blue has a wage claim potentially just to reach out to a mediator on their own. I don't know that would be very fruitful, because the mediator can't then say, oh, let me go reach out to the defense side and let me do all these other things for you. It crosses over some lines. So it really would be best to have an attorney, unless that person is going to represent themselves, in which case it's really incumbent upon them to do that legwork and then bring all of that to the mediator.
Yeah. So there it is. I mean, right there's a highlight. It depends on the field. If you're, dealing with family law, these types of, emotional disputes, maybe it's better to not involve a lawyer. But if you're dealing with a little bit more legal oriented, something where the amounts may be in question and might be up for interpretation, then Anthony, something like that, it makes sense to speak first with the lawyer and get their analysis on the case. And Shayna, finally, just to avoid confusion about having Bob, who's got a wage and hour dispute and going through a divorce, to also be involved in a school dispute, let's go ahead and separate out and say maybe it's Bob's child was involved in a fight at school, something, beyond just ordinary rabble, something where maybe it's a little bit more serious. How would that process unfold for Bob and his child as they get through that particular dispute?
Sure. So with restorative justice practices, we're really prioritizing the relationships amongst the people affected by the incident of harm. And so our methodology involves talking to all of the folks involved to learn more about what happened, how everyone has been affected, what can be done to help repair the harm in a collective manner, put supports in place to address the root causes, and really have an opportunity to explore what is it that everyone can learn from this, to learn how to behave differently, and also get to the understanding of what supports are needed. So typically, we start with the person who's been harmed first to ask them if they're interested. So I heard my colleagues talking about this is, can be a voluntary process. This is something where we want to invite people to try. If they're interested, we would move forward based on the interest of the harmed party. Then we ask them those same questions, the what happened, who's been affected, and how, what could be done to help make things better. And they guide us in terms of, do you want to come together with the others to speak? Do you want to have a conversation with them with support from other caring adults in your life? So Bob could be the caring parent, or maybe the student is interested in bringing their older sibling who's an adult, or a relative, or even involving the coach at the school. So with restorative conferencing, we really open up the conversation to include a support system, which enables the facilitator to be able to tap those folks in terms of moving forward. Once everyone has a chance to talk about how they've been personally affected, that's where emotion comes out and that ability to connect as human beings. And it often leads to apologies and also ideas on how to fix it, how to make sure it doesn't happen again. So the facilitator, is incumbent upon them to write all of these things down and then follow up to make sure that those agreement points are being followed.
All right. Well, thank you, Shayna. I think we're all in agreement here that mediation is a tool to help the affected parties create a solution for themselves. And it's wonderful to see that happening at a school level in addition to at a more mature level. So that kind of handles the when. Now let's talk about the how. So Claudia, let's bring it back to you. As you mentioned, chances are Bob and his spouse maybe have had this conversation. Maybe they are thinking about getting a mediator involved. How would they actually go about getting that process started? Should they just Google search results, or should they get in contact with an organization
They should
first?
go to scmediation.org and use our mediator directory.
Mhm.
But yeah, they do need to look. You can, of course, Google, but why would you Google when there is an organization that's been around informally since 1989, informally since 1991, that really exists to advance mediation? So come to SCMA and look at our directory. And then, especially when it comes to family mediators, you need to be comfortable with the person who is mediating your divorce. So go interview them. We usually all do some sort of free consultation. Bring your spouse along, right? Like, because if you have to sit in a mediation, but you can't like have your spouse next to you while you interview the mediators, mediation might not always be the best fit. It could work. You could be in breakout rooms. That's just going to cost you more time and more money, but interview mediators, because while mediation isn't free, it is voluntary. So you have to voluntarily agree to mediation. So you should both be comfortable with the mediator you are choosing. And you can only do that through conversations. And sometimes it's a fit and sometimes it isn't. And you won't know until you talk to them. And no one's going to be surprised if you tell them, oh, I'm talking to other mediators. Okay, great. That's absolutely normal in this type of, in this practice area, that people talk to a couple mediators, they bring their spouse, you and your spouse make a decision, Bob and his spouse make a decision together of what mediator we're going to work with. It's just a smart thing to do, right? It's a smart thing to do.
Yeah, I mean, that makes sense to me. You work together with your spouse to find a mediator that you're both comfortable with, because if you're going to be settling the dispute, you need to find somebody that you click with. That
Yeah.
makes 100% sense to me.
That you trust, because it's such a personal thing. It's such a personal issue. People tell me things all of the time, and mediators are bound by confidentiality. So if you're going to, they're going to see your finances, they're going to know all of these things about you, know about your kids. You really have to be comfortable with them.
Yeah, that makes total sense. Anthony, why don't we now turn to you and ask the same question? Is this something that the party themselves can start, or is this better to go through their lawyer, say, hey, I think I'm, ready to mediate this. Can you get in contact and figure out the details yourself?
Yeah, it's a good question. So I think when you're probably going to need to have an attorney involved, it is best to let them kind of direct the search for a mediator. I do agree though with Claudia that if it is a family law dispute, that's different. Because I've actually had the situation where I've had couples reach out to me and ask me about doing a divorce mediation or something like that, and they actually wanted to meet with me on Zoom together. I mean, not necessarily in the same room, but they would both be on on Zoom separately, but in the same meeting to almost like interview me. And I remember the first time somebody asked me to do that, I was like, "What do you mean interview me? Like, what are you talking about?" Because it's so foreign to us in the like non-family law world to do that. But it makes sense in light of what the issues are, and it's a much more personal connection, because it does, like Claudia said, it digs so deep into all these personal financial issues and all this sort of thing. And anyone who's done any kind of family law work as a mediator, as an attorney, or on the bench or whatever, how deeply personal and intimate these relationships and interactions can be. And so that's a little different for sure. Like, absolutely agree that you probably should have some more personal involvement with the mediation selection process, 100%. On the employment or personal injury or business dispute, whatever side of it, it's a little bit different because the relationship or interaction is going to be very much primarily between the attorneys and the mediator. That being said, you definitely, of course, want a mediator who's going to be very personal and be able to engage with your client. But I'll be honest, there are a lot of mediations where the actual litigants are not very involved. I think a lot of times it helps the process. Other times it doesn't. There are times where we tell the attorneys, your client needs to be there, even if it's on Zoom. And lo and behold, you show up the morning of, and oh, where's your client? Oh, they're on standby. They're somewhere. Oh, they're available if we need them, and this sort of thing. And so the actual litigant somehow becomes detached from the process, which is really not the point of the mediation. But unfortunately, a lot of the time, the attorneys do take over the process a little bit. And as the mediator, we try to be flexible. At the end of the day, do we know that the actual litigant is approving of whatever agreement is worked out? We need to make sure that that's the case. But hey, if they want to be at arm's length in the process, then so be it. We try to be flexible. But I definitely think you should defer more to the attorney in that process. Now, that doesn't mean you should not be involved. I know that there are some cases that involve more personal disputes. Like, I've dealt with intra-family disputes, whether involving real estate or business or whatever. And sometimes they say, hey, we're from this culture. We want a mediator who has the same background. I've been approached by folks who wanted somebody who spoke Arabic, and I'm not a native speaker, but I speak fluent enough that I could manage. But they really wanted somebody who spoke Arabic, and there's just not a lot of mediators who speak Arabic. So, I fumbled my way through it. It worked out okay, but sometimes they do want to be involved from that angle. And so it really just depends on what the nature of the dispute is. If it's a more run-of-the-mill thing, then maybe it's not as important than, let's say, if it involves something very intimate, like your culture or family thing or whatever the case may be.
Okay. So that's a great highlight there, that it depends on the level of emotional entanglement, it seems like, where the less emotionally entangled it is, the more likely it is that the lawyers are going to be the front runners, kind of leading the process, as it were. And then Shayna, let's finally turn to you and say, in this hypothetical, whether Bob is the parent or a coach or some other, good role model for the child, how would this process get started? Is this something that the school would initiate, or would the students need to get in contact with an organization or something first?
There are organizations that are approached it in a variety of ways. At the Western Justice Center, we're a nonprofit that's committed to partnering with school districts. So in our case, we build relationships with the district and also the school sites. And we have a referral system, so that enables administrators and also faculty and staff to be able to contact us to let us know that there's an incident of harm that happened. And then from there, we can work with them in partnership to be able to bring the necessary parties together. One thing that comes to mind in terms of our facilitation process is, you mentioned the supporters, like having those adult supporters there, it really bolsters young people's confidence to be able to share more openly. And also, in terms of the rapport we build with the participants, we really work to build a comfort level and a trust when it comes to the prep. So the prep is really important before we bring people in distress together to be able to talk about these difficult matters, really, building that rapport ahead of time, and then helping them understand that as a facilitator, our role is actually to take a step back, to allow them to have that conversation so that we're guiding them with questions and really putting the emphasis on them to be able to manage the conflict. And then also, with our support, move on and progress based on the agreement points that they come up with.
All right. So it sounds like your specific organization creates infrastructure for the school itself to
That's
handle
right.
these issues. But there are some other organizations that exist outside of the school system that help. So it's good to know that there are those tools available to help students overcome interpersonal conflict in their own day-to-day lives and give
That's
them that autonomy. And you touched on it a little bit, and I think maybe now's a good time to jump into it a little more wholeheartedly, is talk about the process itself. So now turning back to Claudia, let's say Bob and his spouse, they found a mediator they're comfortable with, they're ready to move forward. In this, introductory setting, should they expect to sign a lot of forms? Is this like buying a house where you've got 17 different disclosures and, who knows whatever else other permits need to be involved? Or is it a little bit more straightforward of a process that they should expect in terms of paperwork?
So is a divorce. There's nothing straightforward about divorce. It takes one paper to get married and like 30 plus to get a divorce. But where family law mediation tends to be different than other mediation is, this is not a grind it out. We're not going to meet for 4, 6, 8, 12 hours to finalize your divorce. You built a life together. Most people aren't going to be able to end it in one day unless they've done a lot of work beforehand. So in general, family mediation happens for an hour at a time. You meet with a mediator for an hour, and then you come back a few days later because you got to calm down. Your nervous system has to calm down. And sometimes the problem with that is that people change their minds. But here is the thing. This isn't, you're not going to be coerced into an agreement. No, in any mediation, you're not going to be coerced into an agreement. But because this is a divorce, even if you reach an agreement in mediation, you're going to have all of your final judgment paperwork drawn up and signed. And if you're not represented by an attorney, you got to make sure it gets notarized. It's got to get filed with the court. So you reach an agreement in mediation, and that's really important. But there are some legal steps that have to be completed to actually finalize your divorce. So it's not just like we've got an agreement. That's great. You got to make it legitimate. The other thing I like to tell people in terms of the process, and tell me if I'm missing something, Michael, if I forgot your question, is it's really a good idea to have your financial disclosures done first before you come to mediation. That way, the mediator can help you with your negotiations around spousal support. The mediator can run child support number. They can see everything you owe and own to make sure everything is included in your agreement, and we know who's getting what and who's paying for what. It is a little bit of minutia, but you want a really clear agreement so that you don't have disputes later on. So there's, I like to say it needs to be so clear that if you were to show your agreement to anyone walking on the street, they would know who gets what. There shouldn't be loopholes. It should be really, really clear. So yeah, it's not, it's an hour at a time, and then you sign once all your paperwork is completed and drawn up.
And then as for starting the mediation itself, should they expect any additional paperwork from the mediator, or should it just be focused on the divorce paperwork itself?
Well, I mean, there's always an agreement to mediate.
Mhm,
And I think we all kind of send out some sort of agreement to mediate where it needs to be signed,
mhm,
explaining confidentiality and those types of things. Um, and there are times where people just need to they have a simple dispute or they're ready to file for divorce, but they've got to figure out where the kids are going to be. Right. And it maybe doesn't involve numbers, but they're fighting about that. So that they can come in at any time for that. But once we get down to the nitty gritty of getting things finalized, they need to have their financial disclosures done.
okay. All right, well, that's wonderful. I realized one last thing. I apologize. I'm just going to take a quick sidestep here and let the attendees know that throughout this webinar, if you have any questions for any of the panelists, on the toolbar on the bottom, there is a Q&A tab. So if you left click on that, you will be able to type in any question you might have for the panelists. And at the end of the webinar, we will answer any of those questions. So if you have any questions for the panelists throughout the webinar, please feel free to add it to the Q&A tab. All right, Anthony, now we're going to move to you and say, in this, after, let's just say the lawyers have said, hey, we've got a mediator involved, what should the participant expect to have to deal with from a paperwork perspective after that?
Yeah, so if we're just getting into like nuts and bolts,
Mhm,
basically, if you are dealing with an attorney who's handling the process, if you will, generally what would happen is if the parties have agreed, hey, let's try to go to mediation, then the parties will exchange some names of mediators, say, hey, here are three people we know would like to use, and then say, okay, here are four people we would like to use, or whatever. And then go back and forth, and eventually they might settle on a name and say, okay, we're going to use, Mr. or Miss, Jane Doe, John Doe, whatever, at whatever panel, which you don't have to use somebody on a panel. Like there's several larger panels that,
mhm,
a lot of mediators are part of. Then there's some smaller panels, and then there's some folks that are independent 100%. And whether they're independent or in a panel, whatever, it doesn't mean that they're better or worse or more sought after or less sought after. Some of the most sought after and most experienced and accomplished mediators are independent, and then others are in a panel. So for folks who are, who ask sometimes like, well, what's the difference and why is this person on their own? Were they not good enough to get on a panel? Like, no, that's not it. They were on a panel and they left. Um, because they wanted to be free to do their own thing, and not have to give any part of their mediation fees to a panel. So there's nothing to glean from they're on a panel or not, or whatever the case may be.
mhm,
But once that person has been selected, then what would happen is somebody from either firm would reach out and say, hey, we've agreed to use you. We'd like to book you. In theory, they would have already gotten their availability in advance when proposing their name to make sure that they were available. So they'd already know the availability and say, one of the dates that you gave us is available for full day or half day mediation. We'd like to book it. And usually they'd reach out to that person's case manager, and then go through the booking process, which would entail, maybe filling out some initial form, depending on who you're dealing with, and then certainly, like Claudia mentioned, at some point signing some type of agreement, a confidentiality agreement or whatever else, making sure to pay the mediator fees in advance. And then, of course, you have to let them know, are we doing this in person or on Zoom? Which I would say probably, I don't know, I can't speak for Claudia or Shane on this, but 95% I would say, give or take, these days seem to be on Zoom, maybe depending on the field, or the locale, but at least so far in my experience, I'd say, yeah, 90% maybe for me. But that can differ, of course, from person to person. But you generally will have an option to do it in person, and so you'll need to figure that out as well. And then the panel or the independent mediators case manager will work out all the details from there in terms of, okay, this is the date, here are the directions to get here, or here's the link to get on Zoom, here's the deadline to submit your mediation brief in advance, which can be very important in a lot of cases. Well, actually, I think it's important in every case, to be perfectly honest, because the mediator, most people don't realize, the mediator doesn't know anything about your case. The mediator's not the judge. The mediator is not the attorney. The mediator can be an attorney. The mediator can be a former judge, but that doesn't mean that they know anything about your case, and they have no way of finding out anything about your case other than possibly if it's already in litigation, to literally go on a court website and start paying to download all the documents that have been filed with the court, which nobody wants to do that. Nobody's probably going to do that. So you need to make sure that your attorney does a good job to tell your story and give all the critical information in that brief so that the mediator can be prepared in advance and not just show up and wing it. Because like nobody wants a mediator who's just going to wing it the day of. That's not a good way to handle mediation, certainly, but also for the participants, you want to give everything that you feel you need to give to the mediator so that they have the tools there ready to be able to assist in the best way that they know how. And so it really is incumbent upon you to meet with your attorney in advance, say, hey, listen, I'd like to make sure you're including XYZ information or whatever the case may be, or can you explain XYZ to the mediator now? Obviously, the attorneys are like, oh, don't worry, I got this. I know what I'm doing, right? So that might not be a fun conversation to have, but it ultimately, as I tell folks all the time, it is your case. It is your decision. Nobody can tell you to say yes, and nobody can tell you to say no, and you have to live with it. So, and that's your way of kind of reaching through the screen and be like, wink, wink, hint, hint, like it's your call here at the end of the day. And I know, Claudia is nodding there. I mean, family law is like so much more difficult because what I learned when I first handled some family law work was that wait, nothing's final. What do you mean nothing's final? What do you mean judgment's final? No, not in family law. You can go back and go back and go back and change it. You can change your mind and go back. And so it's like the craziest thing ever that you could like spend all these hours with people and have an agreement, and then somebody gets mad because somebody sent like the wrong emoji in a text message. They're like, everything's off. I changed my mind and we have to start all over. So yeah, it's a whole special thing.
And Anthony, or maybe the case the judgment gets rejected on a technicality.
Yeah.
And they're like, oh, perfect. And they just pull apart their whole agreement. Right. But let me tell you, that's rare though. That is very, very rare. And your spouse, if they're going to do that or not. You're going to be okay.
Yeah. All right. Well, thank you, Anthony, for that great look into how to prep. And finally, Shayna, let's turn the spotlight over to you and ask the same question. Is there anything that a participant should expect to deal with paperwork-wise after starting this process?
So what's interesting about the restorative conferencing model is it is based on Indigenous practices. My particular methodology is adapted from the Maori people of New Zealand. So really prioritizing that face-to-face interaction, leaning a little bit away from the paperwork notion. Sometimes in our schools, we'll ask students to write a written statement describing what happened, and we're missing that relational piece. So we have to take a step back and think about what is the system that we're serving? Are we serving the system, or are we serving the humans that exist in those systems? And so, it begs the question, can we sit down with a young person and learn a little bit about what happened rather than having them sit by themselves and write a statement? Can we invite them to have a conversation with others who are involved, to have that face-to-face conversation? Restorative conferencing is most effective in person. We did pivot during COVID and handled some cases online, which actually went better than expected. But we do prefer the in-person sitting down, being able to talk. The other piece that comes from these conferences, the 95% of the time, they come up with agreements. So the facilitator, it's incumbent upon them to take notes based on how the participants want it phrased. And so that ownership of how they want to move forward is really instrumental. It guides them. It's their words. It's their idea. So it's self-determined. It's not the facilitator sitting in that position of authority. So really having that written agreement afterwards that people can sign, and then we make copies, we make them available to each of the participants, and then we follow up. We have dates assigned on that agreement of when we can follow up to make sure that things are followed through. So nothing's left to chance. And imagine how different this is than a typical discipline case where students, if they fight, they're sent home, they're asked not to talk to each other when they come back. What sort of solution are we really looking for when when we ask people to not engage with one another in that way, but rather, how can we have this opportunity to give them a chance to really work it out, identify those root causes, and come up with a path forward that everyone can benefit from.
Yeah, that's a very good point about letting the participants self-determine their own solutions and the importance of that. So thank you all for that perspective. Now let's talk a little bit about the timing of it all. I imagine this will probably be a very short question to ask everybody, but let's say the process has gotten started, they've signed their initial paperwork of, confidentiality and whatever else they might need to sign. How long do is the turnaround here between starting this process and actually sitting down with a mediator? Is this something that participants should expect to wait years for? Or something. I saw your eyes go wide there, Claudia. But yeah, no, because a lot of the times in a courtroom, you might be looking at that type of timetable from when you file your lawsuit to getting an actual judgment. So, let's talk mediation now. Are we dealing with similar timeframes, or are we dealing with a much shorter time frame between starting this process and concluding it?
Okay, so just talking for family law, and it really depends on the mediator you've chosen. Hopefully they can get you in within a couple of weeks. And this is one of the reasons why people choose mediation, because the courts are backed up. It takes a long time to get on their calendar. And if you want to get things settled, if things are amicable, if I've had people who are like, but I have a wedding coming up. Let's not schedule your wedding until you get your divorce finalized. But you're in a mediation because it's going to go a lot faster. You're going to get in within a week, a couple weeks, depending on where you are in the process, versus waiting a few months just to get on the court's calendar. And that's not for a trial, that's for a hearing. So quick, couple weeks.
Anthony, is it same kind of timetable for you, or is there more variables involved?
And just to make sure I'm understanding the question really, meaning in terms of getting finality in whatever case that's being mediated.
Yeah, let's say whether it's a successful mediation or unsuccessful.
Oh, wait, I'm sorry, Michael. I thought you were saying how soon can you get a mediation scheduled, not resolved.
Oh, yeah, that is a very, very valid difference. I apologize. Let me clarify that, because yes, as you mentioned, Claudia, family law can take a while. That can drag on for a little bit, as people change their minds and things like that. But Anthony, is that something that happens for your types of mediations, or are they tend to be cut and dry where you have one session and then you're done?
Well, the good news is, whichever interpretation of the question we have, I can answer both fairly quickly. And then I don't know if Claudia wants to add to that as well. But yeah, I mean, you can get in pretty quickly. It's just a matter of, availability, right? I mean, some weeks we're like just totally booked up, and others are a little bit more open. And most mediators that I know tend to not want to be fully booked 5, 6 days a week. They want a day here, a day there. You have other things you got to do. You got to prep. And honestly, people think that like mediation work is like so easy because all you're doing is just bringing peace and this and that, whatever. And it's like, yo, it is damn hard work. Like when you're done, even when a half-day mediation, when you're done with that 4 hours or whatever it is, you are completely exhausted because at least the mediators that I know, they give everything that they have to trying to help these folks out, like everything emotionally, intellectually, whatever. And it is really, really hard work, especially when you're dealing with people's emotions and this and that, high conflict situations. It's really, really hard because you have to be the one to bring the temperature down and to keep everyone engaged and, this sort of thing and whatever. And so it is really, really difficult work. And so sometimes you need that time in between. So it just depends. Sometimes you get cancellations or something happens, whatever, and you have an opening. And other times you're like, yo, I don't have a date open for a month or 2 months or whatever. So, but it's quick to find a date and then to book it. Yeah, as Claudia said, that could be very quick. On the back end of it, Again, family law is different, of course, but on the back end for civil non-family law disputes, literally, like you could have everything done that day, sign the settlement agreement, and then file it with the court, or not the agreement itself, but file the notice of settlement with the court. And now, in reality, it doesn't happen that quickly because generally we may get what's called an MOU, a memorandum of understanding, which is like a 1 or 2 page bullet point agreement if we need something really quick, just to, so people have something, in paper or on paper that's signed. But most attorneys have a settlement agreement, long form settlement agreement ready to go when they go to the mediation, and usually get signatures within a day. And then if it's involving personal injury or employment or whatever, all they need is a W-9 form generally, and then the signed agreement, and they'll say, okay, you'll get a check within whatever, 5 days, 10 days, 15 days, blah, blah, blah. And then plaintiff will agree to dismiss the case with prejudice, after having received the check and like within a few days thereafter. So yes, could you rush that process if for some reason you needed to? Yes. But generally, yeah, I would say that'll take like 2 to 4 weeks to actually get the case fully dismissed in court, once the person has received their settlement check and whatnot. But you could absolutely speed that up if you needed to. It's just a matter of how quickly they need to arrange that. If for some reason they need to get it done sooner, like they have a trial date, for example, coming up, and they want to do more than just file a conditional settlement with the court. Some judges will take court dates off calendar on a conditional settlement, but sometimes you need to make sure that the actual request for dismissal is on file. Some judges say, no, I really want to make sure that this is done. It's not conditional. That just really depends on the judge.
Okay. So it sounds like for non-family civil, it's a little bit more cut and dry, where you set the date, the parties come in, they sit down, they hammer out everything they need to hammer out that in that session and move forward. Whereas,
well, assuming you have an agreement. Yes,
yeah,
sorry.
assuming you have an agreement.
Sorry. Let me make
Yeah.
Assuming you have an agreement. I often have to do follow-ups, like a lot of other medias. We follow up, and we are settling cases often in the follow-up phase, which means the case didn't settle, but we got the parties to make progress, and we don't want to just let it go and then nothing happens. So we have to be the ones to follow up with both sides and re-engage them and text them and call them and email them and keep just bugging the hell out of them until they finally say, okay, fine, well, and so in that case, it could drag on. It just depends on how much time you put into those follow-ups and how long it takes to get them to finally come to an agreement.
And then Shayna, let's turn now to you. Same kind of process. What kind of time frames are we dealing with here? Is this something that would drag on for a little bit, or are schools very fast acting when it comes to these types of conflicts?
It's really case by case, but I'll give you a few examples. It typically is a one-time meeting, and we attribute that to the fact that we do prep each party ahead of time, give them thinking time, what they want to see happen to make things better, to really hold people accountable so they learn from it and learn how to behave differently, that kind of thing. So they come with ideas to the meeting. Time is always our enemy. People really worry about, do we have to take the time? Well, yes, we actually do need to take the time. And we see a variance. I'll share with you, my shortest restorative conference was an uttering case. What that means is a child jumped the turnstile at the public, for the subway. And the police officer, the parent, and the student came together, and it took 10 minutes to resolve. I had another case where there was a 17 student fight in a cafeteria. So imagine bringing in all of their supporters. We had 60 people at that particular conference, and it took 2 hours, and it ended in a really wonderful resolution. As you can imagine, the story, the what happened piece, it was pretty easy to for people to share that piece of it, and then talking about how they've been personally affected. Going around the room, they related to each other, talked about, oh, same for me. So that went really quickly, and then coming up with the actual resolution. The whole facilitation process took 2 hours. So it's it really does vary, but on average, they take about 45 minutes to an hour, typically.
Okay. All right. Well, that I think kind of gives you a whole sampling of different ways that mediators approach problems in these different fields. You've got, again, as Claudia mentioned, with family law, it seems like nothing's ever final. It sounds like they can keep going back and changing things. Whereas it sounds like with Anthony, it's bit more cut and dry. You have and Shayna, you have your setting where everybody comes to sit down and you try to reach full resolution within that single setting. And I think now we can jump now. We talked about it a little bit, Anthony. You mentioned very briefly about follow-up, follow-up, follow-up. But now I'd like to ask kind of a final question here. Let's say we've gone through the process, we're reaching resolution, whatever that might be, whether it's successful or not. What should the participant expect to happen after the mediation concludes? So Claudia, let's start with you. What should a participant expect to have happen?
Well, in family law, they should expect, with the exception of exchanging money, they should expect to abide by the agreements that they've made while they wait for their judgment to be finalized. So if they've made agreements about the children and what's happening there, they should go ahead and implement that. But they need to expect that there's paperwork to sign and that there's a waiting period, and that it really is subject to the approval of the courts. And it depends on where they are. If they're in Los Angeles, you're going to get your judgment back in a couple of days. If you're in Contra Costa County, might be 8 months. I'm not exaggerating. I'm not exaggerating. So, yeah, they can expect to wait.
Mhm. So it's just a matter of, hey, if it's successful, implement whatever needs to be implemented.
And the other thing they need to do is they need to review the documents because they have to sign the documents. They need to review the documents that were drafted to make sure that they are accurate. Now, if you're and even if you have an attorney, you need to make sure the attorney's drafting of those agreements are accurate before you sign them.
And is this something that they should expect to collaborate with the mediator on, or is this something more incumbent on the party themselves?
Well, it depends on who drafts the document. So if you are working with an attorney, and it's not uncommon for people to work with a consulting attorney. So maybe they didn't hire attorneys. They're not being represented by an attorney, but they're consulting with an attorney to get legal advice, to get somebody to look at things from their side of point of view. Sometimes people come back and change their agreement, but whatever the final agreement is, whoever is drafting that document, you need to be working with the person drafting the document and CC your spouse to make sure that they're aware that, yes, this is wrong. Or, you know what, actually, that's not my retirement account. That's their retirement account, because typos happen. So expect to be communicating with people and make sure everything is correct. Because while people can go back and change their minds, unless there's fraud involved, it's very, very difficult to change a divorce decree. So you can change it up until the time you send it to the court. So you want to make sure it's accurate because it's very hard to pull it back after that.
Okay. All right. Well, that's a nice glimpse into kind of how things play out after the mediation concludes with family law. Anthony, can you, explain a little bit about what to expect in the non-family law civil world?
Yeah, so I think as you mentioned, I already kind of covered that in my earlier comments, but one thing I probably kind of just jumped ahead a little bit too much. I apologize. I wanted to point out that, for during the mediation process, there are a lot of differences, especially, and I think that's probably the biggest distinction between what Shayna does, what Claudia does, and what I do, is that, their mediation processes are generally going to be a lot more collaborative and joint. And in my mediation processes are often completely separate. It is rare, and I mean rare that I have the parties ever together for anything, even when I do family law. And there are a number of reasons for that, and we don't have time to really get into all the reasons, but for folks that have not been involved in mediation, and they're like, oh, do we just all get in in one big meeting room and then we start yelling at each other and the mediator's in the middle? Like, what exactly happens? And so some people actually, that you talk to that have no interaction with the legal world at all, they actually think that, and why should they know? I mean, why would they know? And so just taking a step back to that for a moment, that's something you should definitely talk to if you have an attorney to talk to them about. Because frankly, the attorney might not even know what the mediator's process is. And if you don't feel comfortable having that joint session with the other side, you need to let your attorney know. And if you don't have an attorney, let the mediator know, because that's something that I always leave as an option. It's not that I tell them, no, we're not doing it. It's that I say, listen, if there's something that comes up where I think we may need to have the parties talk, I just want to let you know that that's open to you. And most of the time you'll say, no, 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 no. I don't want to. I don't feel comfortable. I just want to deal with you. Can you just go back and forth to the rooms? I don't want to have. It's a traumatic or whatever the case may be. And so you have to be really careful on a case by case basis to know. And of course, I really would love to also hear what Claudia and Shana think, because they deal with this a lot more in terms of the joint sessions. But it's really hard, and it's where the mediators' experience and expertise really comes into play, because they have to use their judgment call to maybe say, hey, I think it would be helpful, or maybe not helpful, or just, hey, the person really doesn't want to do it, just let's not do it. But it's a very tricky thing, and sometimes having that joint session versus not, or whatever, might be the thing that helps unlock the case and get your settlement. And so it really just depends on the case. But I just thought that might be something that that Claudia and Shannon want to talk about their experience with as well.
Yeah, no, that's a very good point about the process itself. Is this a collaborative process where you're trying to bring the parties together, or is it more of an evaluative process where you're looking at numbers and you're trying to figure out, which settlement number is most applicable? So I think that's a very valid point. Shayna, I'll go ahead
Sure.
and ask you that as well. Is, in addition to how these parties would behave after the mediation
Uh-huh.
is done. I'll also ask you, is this a collaborative process? You had mentioned earlier where you bring everybody together in a room. Is that how all of these or most of these mediations play out? Or
That's
do
right.
do you have something more like Anthony where it's separated?
So in our process, it's really driven by the participants. So we ask them, starting with the party harm first, what would you like to see happen? Would you like to come together? Are you interested in making this, making it possible to have a face-to-face conversation? And so it's really driven by the participants, how to proceed. But mine typically are the bringing people together. The philosophy being that we believe that if people are given a structure and a space, that they can and will come up with really wonderful solutions for their own incidents of harm, or ongoing incidents of harm. So it's really having faith in the structure and the space that we're providing, and having faith in the participants who guide us in terms of how to move forward. I'm trying to think if I'm answering your other question. I think it was something to do with just the
Oh,
follow-up, like with the
yeah, what to
agreement.
expect at the end.
The agreement
Once.
is really great because people sign this agreement, they're given copies, and then we have that follow-up just to touch base, see how things are going. Oftentimes we'll run into students who will say, yeah, I took this very seriously, and they'll pull it out of their backpack and show the agreement, and this is their word. And then adult supporters can also, talk about like what follow-ups they've had with the students. So that piece of paper really helps guide the group.
Okay. It looks like we're at 1 o'clock right now. We've got a little bit of time to go over, but I totally understand if anybody in the audience has to leave. Thank you so much for your time. Thank you for taking time out of your day to join us. Please, every day this week, we have new webinars. So covering different topics, please join one of the other webinars if they look interesting. We'll wrap this up by Claudia asking you one last question regarding the process itself, and then we've got one Q&A question. So I figure once we've got the answers for that, we can go ahead and wrap up. So Claudia, just very briefly want to ask you about the process. Is this a collaborative process where you bring the parties together and focus on joint solutions? Or is this something where it's a little bit more separated, like Anthony performs with some of his mediations?
It's a combination. Occasionally I have clients who are in breakout rooms because the conflict is so high, but that's rare. We're usually in joint Zoom sessions the entire time. However, there are times when somebody's about to cuss somebody else out or they're about to break down into, right. It's right.
Yeah.
You cheated
Yeah.
on me. I can't believe you did this.
Yeah.
I, really, really. So sometimes it's like somebody's got to calm down, or so I send their spouse to the waiting room and I talk to them one-on-one, and we trade spaces. Somebody might need help coming up with an offer, or they need to kind of talk through that, and then we present it to the spouse. And everybody has that opportunity to talk to me privately. And it's totally up to them. It's not something where you have to talk to me, you have to be together no matter what. That's just not for me. The way I practice, that's not reasonable. Sometimes they just want to talk to somebody by themselves.
All right. Great. Thank you all very much for that, for those answers. Thank you all to our panelists for joining. I have one last question from the Q&A here from Samar Summer Hadrus. I apologize if I mispronounced the name. It's got a question here for Shayna. Shayna, what training programs would you recommend for mediators interested in expanding their services to include restorative conferencing?
Well, there are really reputable groups out there. You can do a little Google searching. I got my specific training from Dr. Lauren Abramson out of Johns Hopkins Medical Institute years ago in Baltimore. And she and her Australian colleagues had adapted a process from the Maori. That inspired the work done by IIRP, the International Institute for Restorative Practices. Our hope at Western Justice Center is to also be available as a resource. So if you want to contact me after this particular webinar, you're welcome. And I think, Michael, you're supplying the contact information. Is that right?
Yes, yes. At the end here, I will go ahead and put up all of our contact informations, names. So if there are any follow-up questions anybody has, please feel free to direct it towards the panelist specifically. We've got one.
Can I throw out, sorry, I'm sorry to interrupt. I also want to throw out the idea that Living Justice Press is a publisher, and they actually have resources by state, trainers in the country doing this kind of work. You could check out that resource as well, but I'm happy to talk further offline.
Okay, perfect. And then I got a final question here from Doug Spores. He's asking, it sounds like this is for everybody here. Does the mediator offer suggestions for solutions? Is that something that you do during your mediations? We'll start with Claudia. Is that something that you do, or?
Depends. It depends on the client. Or do you want to hear a mediator's proposal?
Mhm.
Sometimes they say yes, sometimes they say no, sometimes they get mad at me. But it really is at that point where they are stuck. A lot of times in family law, it's, well, this is what somebody else has done. Here's another idea. Here's another idea. Here's another idea.
Okay, Anthony, same to you. Do you expect lots of mediators' proposals, or is this something where you tend to focus on the parties too?
We talk about this a lot at conferences and things like that, because it does seem to be becoming more of a thing that people are immediately kind of jumping to. Oh, we have like a $500,000 gap, but you can do mediator's proposal, right? I'm like, oh, sure, no problem. I'll just pick a random number in between, 0 and 500,000 and hope it works out. And it's like, no. You're not going to get off that easy. Like, you're going to have to do some work here. So yeah, I think but the creative solutions almost for sure probably happen more with the type of work that Claudia and Shayna do, which I think it really does require a lot of creativity, especially the types of, and again, I don't want to speak for them, but I think that's really, really hard. It's easier when it's dollars and cents, right? Like, we're just trying to get a dollar amount. And so I don't have to put too much of my creative hat on to do that. once in a blue moon, there might be some like, oh, an apology letter or reinstatement or some other stuff, but that doesn't happen very often. But dealing with family law or restorative justice, like, and I said, I don't want to speak for them, but yeah, you can get really creative. So I'm sure, for them, like they're often having to put their thinking caps on to try to come up with something. But yeah, again, I don't want to speak for them, but that's my guess.
All right. Yeah, Shayna, let's round it out with you. Is this you kind of mentioned this before in many of your prior answers, but just to kind of solidify it, in these types of restorative justice scenarios,
Mhm.
are the parties the leading
They are.
individual of solutions, or is it the mediator?
They really are. And, again, trusting that people have the ideas and the solutions um, inside of them. And we just want to ask the questions to pull some of that creative thinking out. We're limited only by our imagination. So students come up with ways to help pay for the cafeteria workers' glasses that were broken during the fight, help the custodian clean up the cafeteria at other times to make up for the mess that they made. Um, Tutoring each other, helping each other with school projects, helping teachers with cleaning their classrooms, all sorts of ways that the students come up with. I even had a student come up with the idea of baking cookies for a teacher to help make up for what they had done. So how beautiful of a solution that is. And if I, as a facilitator, had come up with the idea myself, I might have squashed their creativity. So really opening it up to them to think about what makes sense for them and solidify their bonds so that they can thrive. That's the goal.
All right. Well, thank you all again, Claudia, Anthony, and Shayna. Thank you all for showing up today. Let me very briefly put on the page here. So we've got for everybody our photos, names, and email addresses. If any of you have any further questions for any one of us, please do not hesitate. Email us. We are more than happy to answer any of your questions regarding mediation, the process, or the rules themselves. And thank you all for taking time out of your day and joining us for this wonderful start to mediation week. Thank you all for taking time out of your days. I urge you to please join us for the rest of the week as we've got free webinars happening every single day. Please join us and thank you so much for your time. I hope you have a wonderful day and a wonderful rest of the week.
Thank you so much.